Good morning. Or, welcome to Expert Insights on the new U.S. Customs landscape. We're excited that you're here. We have a full agenda. So just to start, some housekeeping items. At the right of your screen, you're going to see a sidebar of the main stage where you can submit questions. At the end of the presentation, we will host a 15 to 20-minute Q&A. It's possible we may go over 5 minutes, so putting that out there now. In the same sidebar, you will see a tab labeled Documents where you can download a copy of today's slides and you'll find other helpful resources. You'll also get a copy of it by email. And then above your screen, you have a button to request a duty drawback analysis from Flexport, which we can talk about later in the presentation. But please click that button if you would like Flexport to reach out to discuss drawback analysis for your business. On a brief legal note, please keep in mind that all the information provided in this session is based on the situation at the current hand and may not be customized to your business specific requirements. We always recommend reaching out to Flexport to discuss your particular situation. Joining me today is Rachel Dean, a Senior Trade Advisory Associate. And we also have a surprise guest. Lee Sandler is founding member of Sandler and Travis and principal. So we're so excited to have him talk about the litigation and share his view on that topic. And myself, I lead Flexport's consulting services. Today's agenda. We'll go through the litigation, just kind of an update on the court cases. We'll provide an IEEPA update on some of the recent actions that have occurred over the last 2 weeks. We'll provide an update on the 301 tariffs, and then go over a bit of enforcement, and then we're going to open it up to the Q&A because I know you're going to have a lot of questions for Lee. All right, turning to the court case update. As you all know, there are 3 separate IEEPA tariff actions at issue today. The reciprocal tariffs, sometimes referred to as the worldwide tariffs, that apply to goods from all countries. The fentanyl tariffs that apply to goods from Canada and Mexico, certain goods from Canada and Mexico, and all goods from China. And then there's some secondary actions that were taken with respect to goods from Brazil and India. So last week, the Supreme Court heard oral arguments from both sides involving 2 lower court cases that were consolidated under this lead case. The 3 main issues that the court is heard, one is jurisdiction. The cases that are pending before the court were initiated in the Court of International Trade and the DC District Court. So if the cases involve taxes per se, they should have been filed at the DDC. If it's purely a tariff case, then they should have been initiated at the Court of International Trade. So we'll see what the court says on that. It's possible the court will send one back to the lower court because it was filed in the wrong, or toss one of the cases because it was filed in the wrong venue. The major question is whether IEEPA authorizes the president to impose tariffs or it's an unconstitutional delegation of congressional authority if it does. We heard last week Neil Gorsuch asking questions about whether the president can issue tariffs in any amount on any country. Seems to be a really broad exercise of authority, and that once it's given to the president, it would be very hard for Congress to take back. And then the third issue broadly is whether specific tariffs are legal. And we did hear some comments last week. The court asked questions like, are the tariffs appropriate in the case of India because they're meant to end the war in Ukraine? So I think there's a variety of outcomes that could occur from these cases, and we'll let Lee tell us what he thinks. Other things to be mindful of. Last week, there was a complaint filed in the District Court of Columbia at the Federal Circuit involving all companies that have paid tariffs on goods from China and the EU, but this would not address the reciprocal tariffs on imports from all countries. It doesn't address the fentanyl tariffs from Canada and Mexico, or these secondary Brazil and India tariff actions. So we'll have to see what happens with that. And then 3 new complaints were filed at the Court of International Trade last week. And one of those cases, 2 of those cases addressed the IEEPA tariffs on goods from Brazil and India. Flexport posted a blog with detailed information about what companies should do. But just to recap here, it's important that you file protests, because any relief granted by the court on liquidated entries, depending on how long it takes the court to decide, would only be beneficial if entries are, if liquidated and the 6 months has elapsed, a valid protest has been filed. It may also be necessary for companies to file post-summary corrections, or it's possible that the court, that customs could come up with some other automated refund. So there's a big question mark around what to do next, but filing protests certainly preserves your options for extended delays in action by the court, or if it's necessary for you to take separate action via a class action or separately. So with that, I'd like to invite Lee to come on to the stage, and so we can pepper him with some questions. Hi, Lee.
Hi there. Thanks for inviting me.
We're so glad to have you. Lee, you were in the room with the court. Can you share any insights? I mean, there were some hard-hitting questions. A lot of us, I did, listen to the recording of it, but you don't get to see their faces. So take us into the room and tell us what you saw.
Well, it's remarkable being in the room, because you're looking at the 9 justices. They're all personalities that we know from the news media and their confirmation hearings. And they're all sitting up there in one room. You can look them all in the eye, and their demeanor, though, is very professional, very scholarly, very judicial, and they are taking up an issue which we hear at a policy level all the time on the news and in the newspapers and in talking to people. But here they're really very much focused on what the Constitution and the statutes say. And it really demonstrates how we take these emotional policy issues and reduce them to a true scholarly study to get them resolved in the courts. The courts are very different than the Congress or the executive branch in addressing issues. On the other hand, this courtroom was different in that there were actually 3 cabinet officers in there also looking at the justices. Treasury, Commerce, and U.S. trade representatives were there, clearly giving a signal to the court that there are important policy issues here and don't get lost in your analysis of the law. That message is very, very clear coming from the White House with the people there and with the statements that the White House has made. What struck me as sort of intriguing about that is that a major argument for the government's support of the tariffs is to say that these were non-revenue tariffs. They're regulatory, affecting international affairs, foreign affairs, which is the power of the president and not of the Congress. Well, that's a power that falls to a different secretary, Rubio at State, and he wasn't present. Treasury was there. And the Treasury Secretary had to listen to the government's primary argument was that these tariffs would be most effective if we'd never collected a nickel. That was Solicitor General Sauer's argument to prove that they were regulatory and within the president's foreign affairs power. Bessent was there, and he's the one that's collecting the revenue. And we all know from the newspapers how the White House continues to talk about the $1 trillion being collected and how this is balancing the budget and how it's going to allow them to give bonuses to citizens. So this was a real moment in time where policy and law are really being highlighted in the Supreme Court. And to my mind, it tells you that this is a case that could go either way. Having said that, I did go into the room pretty skeptical and came out less skeptical about how the decision might come out, thinking that there's a much greater chance that the tariffs would be struck down. When you sit in that courtroom, you come with a predisposition. You know that three of the judges, Alito, Kavanaugh, Thomas, are virtually unlikely to vote against the tariffs in the White House. On the other hand, that Kagan and Sotomayor and Jackson are are highly unlikely to support it and would likely strike it down. So you're 3-3, and that leaves you to look at three other people. Roberts, who has made up, clearly wants to keep the integrity of the court intact. Barrett, who has shown that she can think independently and is a true constitutional scholar and a plain language advocate. And Gorsuch, who has taken strong positions about government having to issue refunds where it wrongly collects money. To my mind, the most telling one was one that Anna highlighted when Gorsuch says that once you've given this constitutional power of the Congresses to the White House, you can't get it back absent a supermajority vote, and that's just not going to happen. And he referred to it as a one-way ratchet, and it made me feel very much like he was going to find a way to invalidate some, if not all, of these to make it clear that there have to be restraints on any delegation of the constitutional authority. And this really strikes at the way conservatives have looked at these issues. One of the highlight of things that, in terms of just the long history of the court and how we interpret our laws, the newest member of the court, Justice Jackson, every one of her questions was premised on reciting legislative history as supporting her view that this was not a tariff delegation authority. And she premised it each by saying, I know the court doesn't look at legislative history anymore. When I went to law school, it was all about legislative history where there are ambiguities in the statute. And the current thinking of the court is there's no such thing as an ambiguity. It's all plain language. We just have to understand the language as it was intended at the time it was enacted. So she's clearly trying to create the foundation for moving back to the old ways of interpreting the statutes. So those dynamics were really very, very interesting to watch. The liberals also made it clear that they also raised the issues about Brazil and Canada and being able to use the authority for issues that don't seem to have any resonance with what the Congress would want. A Ronald Reagan commercial being run by the Canadians, or the issues about presidential indictments in Brazil. Those are, I would think, pretty much indefensible under any of the arguments that would be made in this court. And the liberals noted them, but clearly they are not a part of this case. This is a case only about the fentanyl and the Liberation Day tariffs. Being there was remarkable. So I can tell you, though, that while the demeanor of the attorneys arguing the case and of the court were somewhat scholarly and judicial, it was interesting that the Solicitor General Sauer was the most animated, the most aggressive, the only one waving his hands and when making arguments, the most gravelly voice. He was a remarkably different demeanor than the others that were making arguments. And I would think that I've not listened to the tapes. I'm sure if you listen to the tapes, you can hear the difference.
Yeah.
I found it difficult to follow some of his arguments because he spoke so quickly and so rapidly and jumped from one issue to another in response to specific questions. But as I say, this is a remarkable case in that policy is clearly being pushed very hard and not just the letter of the law.
Thanks, Lee. So can you talk about the potential decision and outcomes? Clearly it's not going to settle all the IEEPA just by virtue of the scope of the cases before the court, but it's also possible that there could be split decisions, right? So we know that filing a protest is really a first step. We may need to file PSCs later, depending on the outcomes, but what should companies be thinking about, and how can they protect their rights in other actions, especially if the Supreme Court makes a decision? They talked about Sauer suggested limiting it to future entries and not past entries.
Well, I think that Gorsuch and Comey Barrett are ones that are highly unlikely to allow this to only be applied prospectively and not retroactively. So if it were to be struck down, I really do think it's going to be an issue where refunds will be issued for whichever duties are affected by the decision. Having said that, it's, everyone knows you're really a fool if you're going to predict anything that the court's going to do. On the other hand, it's more fun to make a prediction than to not make a prediction. So I'll make the prediction and I'll be the fool if I'm wrong. The only thing that you know for certain that you need to do now, in the event that it's struck down in whole or in part, is to make sure that you have all your records intact. And that means importers and brokers like Flexport. All this information hopefully is automated, line item basis, 99 coded entry on line item basis. You need to make sure that you've got the commercial backup for it, because more than likely it's going to be a system where whoever's claiming the refund is going to have to prove that they're entitled to the refund. So that's one thing you have to do, and you need to do that now, whether or not the case gets struck down. In terms of what happens then, you're right. If you have unliquidated entries and the court has struck it down, it's time to file a PSC and try and get that refund quickly. If it's liquidated, you can file a protest. If you do file a protest and you get the refund, more than likely you can also get interest on the money. If you do a PSC, you won't get interest. So depending on the circumstances, you may elect to get the money quickly, or you may want to wait to get accumulated interest on the refund. Those are different items. There's a third category that the lawyers always like, and that is that you can go to court. And were you to file a protest today claiming that the duty was unconstitutional, Customs might deny it on the grounds that you don't have a right to file a protest, because Customs didn't do anything wrong. The issue, they followed the directive of the administration and properly applied the duty. Constitutional questions are a different category, and those are ones where you may not be entitled to file a protest, and instead you would file what's called an I case. It's under the I jurisdiction of the Court of International Trade, and there's no rush to do that, because if you were to file in court, that would cover all of your payments or your entries for the last 2 years, the 2 years prior to filing the case in court. So time has not run on any of that, but that's something you can keep in your hip pocket in the event that something surprising happens in the interim. Um, so those are sort of the categories of things that I think about here. I know that there's also class actions that have been filed. I'd be very surprised if people would get the benefit of a class action and get refunds issued through that. And the reason I think that is that the only class action I'm aware of brought against customs was one that our firm brought years ago for the bonded warehouses to get a refund of fees. The court, after much debate and argument, agreed that it was a proper basis for a class action, but that was because there was no statutory remedy for getting refunds of annual fees charged by customs for bonded warehouses. Where you're talking about duties, whether it's IEEPA duties or ordinary duties or anti-dumping duties, you do have a protest process, you do have litigation processes. There's no need to resort to a class action. So I would think my best prediction on that is that the class actions will not become a vehicle that you need to worry about. But you do need to stay alert to them because, as I said, I could very well be wrong.
That's good information, Lee. One last question for you. What happens with the cases that were put on hold under the lead cases before the Supreme Court?
Presumably nothing happens then until, if the Supreme Court, to the extent to discuss refunds, they felt like this is just a messy, complex process, and hopefully that would lead them to just remand that issue back to the Court of International Trade, where people that really are versed in these things can make them happen. And you may wind up your cases being suspended until there's a court order on how to administer refunds, or customs comes up with its own procedure, or the court just says, go ahead with your normal post-summary corrections and protest processes, and we'll take care of those cases. But those cases should remain suspended. The one other additional issue that I might mention that could very well come up, I don't think in this current litigation process, but at the end of the day, there's a question about who's entitled to these refunds. The government typically, and I think in this case, will be happy to just issue them to the importer of record. However, to the extent that importers of record have negotiated with others to share in those duties and tariffs, you may very well have contractual issues that you might settle, or you might wind up litigation with people that feel that they are entitled to the refunds that you're getting. So I wouldn't be surprised if some companies will fall into that arena and have those types of disputes. But I wouldn't anticipate it's going to happen in the government's refund process. I think it will come after the fact with respect to private parties trying to get some of the refunds into their pockets.
In there, you're talking about the customers of the importers could file their own litigation because presumably they paid the tariffs or it was included in their price, cost of goods.
If I was an importer who negotiated with my exporter and we shared in the tariffs, I got the full refund. He may very well want to get his monies refunded. And if I don't give him, we may wind up in court.
Very interesting. Start talking to your lawyers, folks. Thanks. Thanks so much, Lee. We're going to hand it over to Rachel, and then we're going to bring Lee back. So submit your questions fast.
Thanks, Anna. There's been so much focus on, obviously, the court case. So thank you, Anna and Lee, for diving into that, but also on the IEEPA front. There have been some agreements struck from Trump's visit to Southeast Asia. There was an agreement signed between Malaysia and another one with Cambodia, and there's a framework agreement between Thailand and Vietnam. None of these are in effect as of yet, but they're things to have on your radar. And For the most part, it's going to keep that reciprocal tariff rate in place. So for Malaysia and Cambodia, you're still going to see that 19% reciprocal duty rate, and it is on top of the normal trade relations or the MFN rate. So if your base duty rate is 3%, like a year ago, you were only paying 3%, it's going to be the 3% plus the 19%. There is language in these agreements. In the agreements, they reference Annex 1. But this is actually kind of harkening back to the executive order in September that was designed to kind of grease the wheels to negotiate these trade agreements and get them implemented. And in that executive order, it's items that were listed in Annex 3. So I'm listing Annex 1, Annex 3. I'm getting this a little bit confusing. So let me go ahead and tell you what these items are at a high level. These are products that are basically cannot be grown, mined, or naturally produced in the United States. Certain agricultural products, civil aircraft and aircraft parts, and non-patented articles for the use in pharmaceutical applications. Again, these are IEEPA. So when we heard Anna and Lee talk about the outcome of the Supreme Court case, some of these agreements may be affected as well. But this is what we have right now. These are the agreements that have been negotiated. Thailand and Vietnam have a framework agreements in place. Again, there's going to be items that are listed out that will not be subject to those reciprocal tariffs, which for Thailand is 19% and for Vietnam is 20%. So, and on to the next page here. While Trump was in Southeast Asia, he did negotiate with China. And we know that the IEEPA fentanyl tariff was reduced from 20% to 10%. And originally, the reciprocal tariff rate was scheduled to go up to 34% this month, but that has been postponed until November of 2026. So it's going to remain at 10%. Now, continuing on the theme of negotiating with China, let's get some 301 updates as well. So part of that negotiation was to extend the exclusions for the original 301 tariffs. Now, these are tariffs that went into effect during the first Trump administration. We refer to them a lot of times as 25% China tariff. So there are 178 products that have had the exclusion extended through November 10th of 2026. Also, the implementation of responsive action for China's targeting of maritime logistics and shipbuilding sectors for dominance is now suspended until November 10th of 2026. That was a mouthful. What that means is the investigation is going to continue, but there's not going to be any action based on the findings from that investigation. Furthermore, the investigation of China's adherence to the U.S.-China Phase 1 agreement, which was signed in January of 2020, again, investigation is going to continue, but we're not likely to see any action on that until November of next year. In the 301 arena is also Nicaragua. This is kind of a new issue. In October of 2025, the USTR determined that Nicaragua's actions related to labor rights, human rights, fundamental freedoms, and the rule of law put a burden on U.S. commerce and were actionable under 301. The USTR has proposed a 100% duty rate and suspension of the CAFTA-DR benefits. As a business, you can post comments to the USTR. We've got a link on this, which you will receive these slides later. We'll email them out to you tomorrow. But you can post your comments on that until November 19th. They have to make a decision by December. So whatever is going to happen with Nicaragua is going to happen relatively soon. Now into enforcement. I have a couple of slides here that are directly from U.S. Customs. And this is a high level, and I'm going to go through this kind of quickly because I know everyone's really focused on what's going on with the court case, and I want to kick it back over for Q&A. So let me just high level go through these just to show you some numbers. Now, these are some statistics that are through August 31st of this year, and we can really see an increase in the number of audits. Like by the end of the year, we'll probably have close to 500 audits. And if we look at the funds here, it's already at 192.77 million. By the end of the year, it's likely to be twice as much that was recovered than last year. And again, part of this when we're looking at this net revenue recovered from entry summary reviews, because there's so many more tariff lines, it's so much easier to make mistakes. And also, if there is an issue where you're not including all the tariffs that are applied, if you're applying a 10, 15, 20% duty rate, obviously the funds on that, it's going to go up. So last year it was 667.55 million. And now as of August 31st, it was already 32.95 billion. So if you are feeling this pressure, if you're getting the CF-28s, you're not alone. Here are some numbers from US Customs on that. Also on that front, and this is again from US Customs webpage, I think we're all focusing on IEEPA, we're focusing on Section 232, but that doesn't mean that these other high priority issues with US Customs have gone away. Anti-dumping is still an issue, and forced labor is still an issue as well. And here is, we took the figures from the dashboard and put it into this little line graph for you. There are already 7,200 withhold from release orders this year, which is more than the 2,567 withhold from release orders last year. So there's a huge increase in shipments being detained for forced labor. And again, we already know that 5,806 shipments have been denied entry. So this is just some interesting information. And I am going to kick it back to Anna because I know we want to get to Q&A. We have questions. We want to know what to do about this lawsuit.
Thanks, Rachel. Just give Lee a minute to pop back on. Oh, sorry, I skipped ahead. So, of course, Flexport can help in any way. If you want a drawback analysis, please click the link at the top of your computer. Reach out to our, you can vote yes for the free ACE analysis. Work with one of Flexport's associates, and they'll send that over to you for free. And check out our tariff simulator. It's still free. I heard last week our CEO said there's a new registration requirement, but it's still free. Check out the tariff simulator. It's a really nice tool. I hear a lot of people are using it, even competitors. And then if you want specific advice, there's contact information for the ACE analysis. And if you want to talk to our classification team, we do have a dedicated group of people that help with tariff analysis. Moving on to the next slide. Q&A. All right, Lee, the questions are pouring in for you. One concerns your comment about filing a protest. So if the court doesn't overturn the IEEPA tariffs, I'm sorry, if they do, but does not specifically establish a refund process, you talked about it being remanded to a lower court. You're not saying don't file a protest, right? Or are you saying, the question is, are you saying cite the court decision on the remand as a reason to file the protest?
My advice would be that you need to file a protest no matter what the court does to protect your interests.
Yeah.
Because things can change. 180 days after the liquidation, it becomes final if there's no protest. There have been situations where either the Congress or CBP or the courts would open up the possibility of refund despite the liquidation being final, but don't assume that's going to happen here.
Okay. If IEEPA is, I don't know if they're asking you to make a prediction. If IEEPA is struck down, do you think that the Trump administration is going to implement the same day Plan B?
No.
I don't know if it'll work that fast, but it'll be fast probably, right? I heard they're working hard, like busy little bees, coming up with Plan B.
Well, there's a lot of speculation as to what the government might do. One of them would be to use Section 338 to say that the tariffs are justified under a different statute. It's a statute that's never been used. There's a legal argument that has been superseded and it's no longer the law of the land. But this administration does not fear the cost of litigation. So it's conceivable that the court could strike it down and the government could respond by saying we're not going to issue refunds because we think they were properly collected under 338 or under 112, which is a more limited authority. Neither of those statutes require the Congress to do anything. You're all familiar with 232 and some of the other provisions that where they're allowed to assess duties to the executive branch after there's been a process through the International Trade Commission or Commerce. But those two provisions don't have that type of a predicate. So the president could act very quickly if he chose to do that. I think it's a real stretch of the law.
Yeah, I mean, I think like one likely outcome is we'll see more 232 tariff actions on specific classes of merchandise. Would you agree?
Oh, absolutely. And the administration isn't fearful of doing that. They're filing new ones all the time. But they don't like to have to deal with the time frames in the statute.
Good point. They'll be looking for a quicker implementation mechanism.
And they truly want that authority to be able to negotiate with foreign countries. And that's why, you have two court cases here. There are 5 executive orders with the duties going up and down and around.
Yeah. Do you think, on that topic, one of the justices brought up India and how this was an effective tool potentially, or in theory anyway, for dealing with short of some other stronger mechanism. Do you think that it's possible that the court would come back and uphold certain of the tariffs for specific reasons?
It's possible, but I would think that the fentanyl issue is a stronger issue than the Indian issue or the Canadian issue or the Brazilian issue. But as I said, we're dealing in a policy arena which can push the law to the side and may come out in a way that I wouldn't have predicted anyway.
What are your thoughts on when the Supreme Court will make their decision? Some people say by year end, others, it doesn't seem to be normal. What do you think will happen?
I think year end is possible, but not probable. I'm sure they want to move rapidly, so I'd expect no later than early in 2026. They presumably met the Friday after the argument and took preliminary votes and assigned someone to write a draft of a majority opinion. So the court, I think, sees a priority on this, and they do have a process that allows them to come out quickly. On the other side, once they draw something like that, those that dissent want to write their dissents, and those efforts can delay the court taking any action.
Interesting. Frequently, the major questions doctrine came up. I think they're referring to the oral hearings. Do you think all 9 justices will take this into consideration when deciding the case?
I think it's an issue. To me, the simpler issue was the plain language of the statute. Tariff isn't said there. They always say tariff. But the Voss's attorney sort of gave ground on that by saying that the fact that the term isn't there doesn't mean that it's not authorized. The regulation could include tariffs depending upon the context of the statute. And so that leaves the conservatives to determine what the context is here. And I could argue that either way. Any good lawyer could do that. So the door is open. So the major question doctrine, and particularly that issue about we have a constitution that says this taxing tariff authority rests with the Congress, and this court shouldn't be saying that by inference in a statute that doesn't mention tax or tariff, that we've given that away permanently to the executive branch. That's Gorsuch's position, that reverse ratchet issue. And to me, that would be the most compelling issue, I would think. Whether they say it in their decision or not, I do think that it's highly persuasive to the conservative group in the court.
Okay. We have another question that I can answer. It says, do you suggest filing an extension of liquidation for entries not already liquidated to preserve the right to file a PSC instead of a protest? What I can say is, just based on our work with other clients, we've asked for liquidation to be extended in a separate matter involving the Section 232 tariffs, which also, those goods are covered by the are also covered by IEEPA tariffs. And we were informed by Customs that they're not going to extend liquidation on any entries that have IEEPA tariffs deposited, which seems quite ominous. But Lee, you have any thoughts about that? Supposed to have it extended for good cause, right? Which
extended for good cause, and the other issue with filing protests that you have to take into account is it's not one size fits all. The entries that you're protesting may have issues that have nothing to do with IEEPA that you want to protest, and you don't want to mess up those. So on some you'll want to extend, and others you may want to move it more rapidly. So, but don't get yourself into filing a protest that only says IEEPA. Make sure that you've double checked to make sure that you have identified any other issues you want to include in that protest.
Okay, and then we have another question, which I think I can answer, and Lee, I'll let you finish my answer, but it says, do you have any guidance or links on filing a protest? I mean, these are some pretty weighty issues here, Lee. I think that businesses should work with an expert or subject matter expert in filing any protest, because CBP, what we're seeing is they're looking for a reason to deny protests, even where it seems like it's obvious that the importer is entitled to a refund. We're seeing Customs say, prove it, and ask for, like, every I and every I dotted and every T crossed. But, Lee, tell us your opinion.
Well, if you're used to filing protests, go ahead and do that. If you're not, you should work with your broker or your attorney. Just as you say, it's a legal document. And, I started out my career as a Department of Justice trial attorney. The first thing that we did was take a look at the documents to see if there's any way we could win the case without ever getting to the merits. And that continues to be the mantra at Customs and at the Department of Justice. And so you don't want to file a legal document that is missing some legal element that is necessary for it to be validly accepted and ruled upon.
Yeah. The other issue I think is critical there too is a protest is your last stab at it, aside from going to court. So if you're not someone wanting to go to court, you should put all your muscle into writing a really strong protest, because friends like Lee are nice to have, but they're also expensive. Sorry. Okay, so let's see. I'm going back to these questions. But on the topic of lawyers, I feel like a lot of people are going to be needing them soon. How would a company go about joining a class action lawsuit, or would it be better to file their own lawsuit directly? Could you just maybe opine on that? I mean, you did make some negative comments earlier about class actions, so.
Yeah, well, my earlier comment was that I don't think the class action is going to become a viable vehicle for getting refunds. So, so I wouldn't rely upon it. On the other hand, if it becomes valid, you would be given an opportunity to opt in or opt out of the class action after the court rules on it. So there's no immediate problem about taking advantage of it. You'd have to wait for it to wind its way through the court. Having said that, since I don't think it's going to be a viable thing, you have to make sure that your liquidations have not become final, which means filing a protest. or doing a PSC to get the refund prior to liquidation. And the other thing to, as I said, keep in your hip pocket the thought that if this isn't resolved within 2 years, you can file an I action in court, which means you have to consult with some awful attorney who's going to charge you some outrageous fee, or not. But you can go to court. And I do think, in my understanding of the law, that the I remedy in court is probably the proper one legally, that protests are not correct. Although once the court rules, if it does rule, that they're unconstitutional, Customs is under an order to reliquidate those entries and refund them. That is a protestable issue at that time.
Okay. That's good information. We'll do one more question, Lee. And I know a lot of people ask questions for me and Rachel. Feel free to reach out at one of the contact information emails in the deck, or if you're already working with us directly, and we'd be happy to answer your questions. So, Lee, if the Supreme Court decides the tariffs are beyond the president's authority, wouldn't the administration just, oh wait, I think you've already answered that question. Find another way to, another avenue.
Yeah, we did answer that, and yes, I think that they're likely to do that. Well, I'm certain they will consider it. I don't know that they're likely to do it.
Mm-hmm. All right. Well, thank you so much, Lee. We really appreciate you joining us. Last minute, we had emails going back and forth over the weekend to reach him, and it was a pleasure to have you here. We hope you come back.
Thank you very much for the invitation. I enjoyed speaking with everyone, and I look forward to finding out what's going to happen next year.
Oh, one more thing, folks. Make sure that you write down the NEI if you're looking for NEI credit, the code, so that you can capture that as well. With that said, thanks again for joining us, and stay tuned, subscribe to Flexport's blog, and watch for additional webinars. Take care.